A major change in US immigration rules could make the visa and green card application much less forgiving, especially for the Indians hoping to study, work, and settle in America. The US Citizenship and Immigration Services (USCIS) has immediately changed how the officers can handle the incomplete immigration applications. Under the new guidance, the officers can deny an application if the applicant has not provided the required evidence or failed to show eligibility at the timing of filing. And in some cases, they can do without the first sending the request of evidence, knowing it as the RFE. That is the key change. Earlier, officers were generally encouraged to give the the applicant an opportunity to submit the missing evidence before denying the certain applications. But now, USCIS has restored the greater discretion to deny the cases that are incomplete or seriously lacking required documentation. But there is another important detail. USCIS can still issue an RFE if an officer believes the additional evidence could help reach the decision. So, this does not mean that every missing document will automatically result in rejection. However, the burden is now clearly on the applicant. USCIS says that the applicants must establish that they qualify for the immigration benefit when they file the continue to qualify while the case is still being processed. The policy applies to immigration benefit requests who filed on the pending on or after August 5, 2026, unless another regulation on USCIS policy says otherwise. And this could matter significantly to the Indian applicants. Thousands of Indians apply for the US immigration benefit every single year, from employment-based visas to green cards to extensions of the status and to the change of status and citizenship. A missing document, insufficient initial evidence, or an application that does not clearly establish eligibility could now carry a bigger risk. USCIS says that the change is designed to improve the efficiency, reduce backlogs and prevent what it calls a weak frivolous applications from consuming the agency resources. But critics and the applicants may see the other side of the policy. The opportunity also need to correct a deficient application that could remain less certain, public greater pressure on the application, and then the immigration lawyers to get everything right before the filing.